for her briefing. I now give the floor to Mr. Serge Brammertz.
Mr. President, Excellency, thank you for the opportunity to again brief you on my office's activities and results. Details have been presented in my written progress report. My remarks today will mainly focus on the Council's upcoming review. Mr. President, Excellencies, it's in 2008 you entrusted me with leadership of the ISTY Office of the Prosecutor. So I remember very well when the Council adopted Resolution 1966 and established the mechanism. One key rationale for the mechanism was to address the remaining fugitives for both tribunals at that time. In May 2009, when the Secretary General submitted his report, there were still 15 fugitives at large. At that time, the pace of arrests had slowed, and it was unknown when or even if fugitives would be arrested and trials would commence. The need to prosecute fugitives decisively shaped the mechanism. From its creation, it had to be a criminal court, like the ad hoc tribunals, with a full range of functions. There was a fugitive tracking team from day one on, while a roster of investigators, prosecutors, and judges was needed to conduct trials when arrests were made. When I also took over responsibility as mechanism prosecutor in 2016, progress had been made at all ICTY fugitives, and 5 ICTR fugitives had been arrested. We had a full workload of trials and appeals in the Stanisic and Sematovic case, Karadzic, and Sechel cases. As I briefed you at that time, locating the remaining 8 ICTR fugitives was our #1 strategic priority. We then achieved this goal with Kabuga arrested in May 2020 and Kaishima arrested in May 2023. And so here we are today. All ICTR and all ICTY fugitives have been accounted for. All international trials of fugitives have been concluded. What seemed nearly impossible in 2010 has been fully achieved. Mr. President, Excellency, the mechanism had another vital mandate to support the national accountability process. The completion strategies began the transfer of responsibilities to national authorities. In 2010, this process was still only at the beginning. The ICTR and ICTY were in the process of referring cases to member states. National investigations of other cases were commencing. To support these domestic efforts, the Council gave the mechanism an important new mandate in Article 28.3 to respond to requests for assistance from national authorities. Accordingly, my office significantly expanded the amount of evidence we shared with national prosecutors. We also prepared investigative dossiers for national authorities concerning notable suspects we had investigated but not indicted. We began working directly with partners on their active cases, what we call today direct case assistance. This work complemented domestic initiatives. In Rwanda and the former Yugoslavia, significant reforms were made to prepare for trials of referred cases and assume responsibility for the justice process. Special prosecution offices and courts were established and international law was domesticated and fair trial rights were strengthened. The impact of those international and national measures can be seen in our workload. In 2012, when the mechanism commenced operations, my office received around 100 requests per year. In recent years, we have been receiving nearly 400 requests annually, which are also of increasing complexity. In total, my office has received, since the mechanism was created, more than 4,000 requests for assistance from national authorities. As the completion strategy is intended, our national partners have achieved significant results. Domestic authorities successfully prosecuted the referred cases. In Bosnia and Herzegovina, between 2004 and 2023, courts adjudicated 742 war crimes cases involving more than 1,100 defendants. In Rwanda, investigations were conducted and indictments prepared for more than 1,200 persons. Third states also increased their efforts, with many war criminals and genocidaires extradited or prosecuted, and a significant number of cases ongoing today. And so again, if we compare the situation in 2010 with that today, the contrast is striking. As international justice was winding down, national justice took its place and continued achieving accountability as the Council intended. Mr. President, Excellencies, of course, more work remains to be done at the domestic level, with important challenges that must be overcome. Many victims and survivors are still waiting for justice, while the families of the missing are still searching for their loved ones. The passage of time only makes the need to address their suffering more urgent. Rwandan authorities are still seeking more than 1,000 fugitive genocidaires. In the countries of the former Yugoslavia, more than 1,000 war crimes cases are still outstanding. Addressing these important accountability gaps will require swift and determined efforts by national authorities. International cooperation between prosecutors is essential. In the former Yugoslavia alone, there are more than 300 cases to be transferred from Bosnia and Herzegovina to Croatia and Serbia. For Rwandan cases, it will be vital to continue strengthening cooperation between Rwandan authorities and prosecutors around the world. In this regard, I must note that 2.5 years later, Fulgence Kayishema remains in South Africa following his arrest in May 2023. His case is an important opportunity for national authorities to prosecute an international fugitive. Our concern is that Kayishema is effectively blocking proceedings before the mechanism and South African courts, with the result that there is no prospect that he will be brought to trial anytime soon. The Council's engagement with South Africa to determine its intentions and capacity to achieve progress in this case would be very welcome. Too much time has already passed, and Kayishema's victims deserve to see justice finally delivered. Mr. President, Excellencies, as we look forward, the Council requested the Secretary General to submit reports on options for 3 important residual functions: assistance to national jurisdictions, enforcement of sentences, and management of the archives. My office supports the Secretary General's views in these respects. With respect to our assistance role, national investigations and prosecutors will remain at a high level for a number of years to come. Our partners will need access to my office's evidence, expertise, and support to meet their responsibilities. That is why we believe this mandate should be transferred to the Secretariat, so that the United Nations can continue to provide invaluable technical assistance to member states. In terms of early release applications, my office has detailed knowledge of the victims, crimes, and convicted persons, so we will continue to have an important role to play in ensuring that all relevant information is presented in relation to these requests. The transfer of the archives to an appropriate body for long-term management is sensible at this point in time. Regarding the other residual functions not addressed by the Secretary General, my office has presented our observations to the Informal Working Group for International Tribunals. We have endeavored to try to provide objective and transparent information to assist the Council in its review and deliberations. Our conclusion is that options are available to transfer or complete all of these other functions, including the issue of the protective measures for witnesses, as I have detailed in my report. In our view, the transfer of responsibilities to member states should continue wherever possible. This is what the completion strategy is intended. We also believe pragmatic solutions are available to wind down the mechanism's activities. At this stage in this accountability process, the need for an international judicial body has been greatly reduced, and only a few last tasks remain. This is now an opportunity to fundamentally reimagine the mechanism and implement creative, responsible changes. Mr. President, Excellencies, in conclusion, with the Council's continued support and the dedicated efforts of mechanism staff, we can now say that the mechanism accomplished its most important mission. Finalizing the last trials of the ISTR and ICTY was of immense importance to the victims, affected societies, and international community. Looking forward, the future of accountability is now at the domestic level. Here too, the Council played a decisive role in supporting the adoption of the completion strategies and the transfer of responsibilities to member states. My office stands ready to assist the Council in its deliberations and provide any information that the Council may find helpful. Thank you for your attention.
I thank Mr. Brammertz for his briefing. I now give the floor to those council members who wish to make